Judge, that was my final case, if I could be excused.
You are excused.
Thank you. Have a good day.
Thank you, you too. We'll now take up case number 2025 TR 785, State of Kansas versus Wendell Betts. Jared Regier for the state. Wendell Betts, are you here? I do not see Wendell Betts.
Yes, he's here with me, Judge.
All right, if you'll bring him in. Sir, are you Wendell Betts?
I am.
And
Yes, ma'am.
are you still proceeding without an attorney? You're still representing yourself?
Appearing pro se, yes.
All right, and you still wish to proceed in that fashion today throughout this bench trial that we're set for?
Yes and no.
Well, on July 9th, 25, you did waive your right to counsel on the record, both verbally and in writing by a signed waiver of counsel. And then you announced you wish to set the matter for bench trial today, which we're ready to proceed. Are you ready to proceed?
Yes, ma'am, I am.
All right, and if you're going to proceed on your own, Deputy, do you have another one of those forms for him to sign for trial today, if he wishes to?
I will get one.
Thank you. All right, now, Mr. Betts, you sounded a little hesitant about the attorney this time. What's on your mind? Is there anything we need to talk about? Or?
Well, when I appeared here in July, I told the court that I didn't think I could get a diversion because I've had a traffic violation in 2013, I believe it was. And I don't know if that's still available to me.
Well, you didn't go down there between, you've had since July 9th, you didn't call the county attorney to ask them or go by and inquire?
No, I didn't. Oh, no, I didn't. I talked to him yesterday, but it was a little late. I agree.
All right, so when you talked to them yesterday, did they give you any indication it might be still on the table, still an option, or did they tell you it's too late?
Neither, ma'am.
You didn't ask them about diversion yesterday?
I believe I did, Mr. Regier, I think his name is.
You think you spoke to Mr. Regier yesterday about diversion? Well, what he usually tells me is that's between you and the diversion coordinator, but Mr. Regier, do you have anything you want to share on that issue of whether he can still apply for diversion if the court would entertain a continuance of the bench trial?
With all due respect, Your Honor, as the court is well aware, it is a pre-trial diversion. The state would be objecting to continuing this bench trial for any reason. Based off of the state's records, it would appear the defendant declined to pursue diversion as far back as 2.5 months prior. And so the state does have concerns about this being nothing more than a mere delay tactic. Additionally, there is another pretrial matter that the state feels is necessary to address before this matter proceeds.
Well, let's go ahead and address that then at this time. Go
Your
ahead,
Honor,
Mr.
Your Honor, based off of the state's records at the July 9th hearing, it would appear that the court did make certain orders concerning booking and bond. It would appear that there is a jail affidavit in my file that would appear to indicate that as of September 2nd, 2025, the defendant failed to report to the Butler County Detention Facility as directed by the court to be processed and released. So I'm not sure what the court wishes to do on that information.
Why didn't you comply with the orders, Mr. Betts?
Judge, I just completely forgot about it. I did. They gave me a slip, I believe, to come a week after that, or the following week. My brother went in the hospital and I just completely forgot about it. When we leave here, I can go over there and do it today.
And Judge, I do have waiver signed.
For today?
Yeah, waiver on the attorney.
Okay. All right, well, I don't want him, well, he has an appearance bond that was filed July 11th. You don't have that, Mr. Regier?
I am showing such a bond in my file, Your Honor. However, the state does consider booking and the issue of booking and the booking of bond to be separate issues under these circumstances.
Okay, so is this one of those where he just signed the paper in the courthouse and didn't go out and get the picture and prints? Even though he was told to do both?
Your Honor, the state would respectfully defer to the deputies at the Sally Port on that issue.
Deputy Throckmorton, can you advise on that?
I cannot confirm any of that. Just whatever the jail records would show.
And I can
I
only
didn't-
go by what the court file shows, what the clerk's file shows.
Regeer defers to the Sallyport boys.
Judge.
Mr. Betts, you want to be heard?
Just briefly. I forgot to do that. It wasn't it's an appearance bond. A book and really go over and get my mugshot taken and fingerprints. Is what my understanding of it was.
Okay,
And,
so the officers had the bond there in the courthouse and you signed it, but you didn't do the second step to go out and get the picture and prints taken. Is that what happened?
Yes, I believe so. Yeah.
Yeah, if he was in person, he would have signed the bond while he was here.
Okay, well, we'll address that half. That is a very important matter. And I do want to take that up, but we'll do that at the end of the hearing. All right, so Mr. Betts, you've signed a waiver again today that you're going to represent yourself through this trial for driving while suspended and improper driving on laned roadway. Are you ready to proceed at this time, sir?
I am.
Mr. Aguirre, are you ready to proceed?
Yes, Your Honor, as a preliminary matter, the state's information is that prior to today's setting, my office did extend a plea offer to the defendant. I do not know if I have any other information beyond that.
All right, so do you know what he's talking about, Mr. Betts? Because plea offers come before trials. You don't wait and see how your trial come out and then decide you want to take a plea offer.
Yes, ma'am. I understand that.
So he's basically saying, I made you a plea offer. I don't know if you're taking it up or not. What's your response?
Trial.
You don't want the plea offer. You want to go to trial. Is that right?
Yes, ma'am.
All right, then Mr. Aguirre's turning down the plea offer. And he didn't apply for diversion, so I think we're ready for trial. Do you have your witnesses?
Very, very well, Your Honor. If I may have a one brief moment of the court's time.
Yes, you can.
Thank you, Your Honor.
You're welcome.
What was that? The brief moment was to leave? He sure was. Yeah, that's my guess. It's just an odd way to put it. But I already miss him. I, for one, salute our AI overlords. Okay. He's back. He's back.
Thank you, Your Honor. The state does have one final oral motion
Grant
for the
canceled.
court's consideration.
Please proceed.
Your Honor, pursuant to the ticket in this matter, this is a case that appears to involve two alleged charges. Count one, driving while suspended, KSA 8262. Count two, improper driving on a lane roadway under KSA 81522. After further review of the file, the state is not prepared to proceed with respect to count two, and the state does make an oral motion to dismiss the same. The state is prepared to proceed fully with respect to count one, driving while suspended.
All right, well, Mr. Betts, they're contemplating dismissing count two, the improper driving on laned roadway. That's an infraction. That leaves you with one count of driving while your license was suspended. Do you wish to proceed to deny that you were driving while suspended in Butler County on April 9th of 2025 and have a bench trial on that, sir?
No,
What do you want to do with that count?
I'll enter a no contest plea.
All right.
Before I
know
do
count-
that,
Go ahead.
before I do that, Your Honor, they dismiss count 2,
Improper
was-
driving on a lane roadway.
which was the probable cause to stop my vehicle. And without that count,
Objection, Your Honor. This is hardly the appropriate time to raise arguments.
Well, I'm gonna let him go ahead. You're making a motion that they didn't, I think you're gonna need to probably reduce that in writing, sir. You'll have to continue this trial, reduce that to a written motion, give it to the county attorney and give them time to respond to it. If you're gonna argue that they didn't have cause to stop you for driving while suspended.
And again, Your Honor, the state is objecting to any additional continuances of this trial.
I understand, but I need to know what he's wanting to do with this case. Are you wanting to move to continue this trial so you can try to get that motion on file and give them time to prepare a response, sir?
yes, ma'am, I am.
Okay, why are you just now making this motion moments before? Because they just now dismissed it?
Well, he's just dismissed it. I mean,
All right, well,
I thought
Mr.
thought
Regier- Okay, go ahead, sir.
yesterday when they made the plea offer, that was part of the plea offer, dismissed count 2 and plead to count 1. And my argument about that motion to suppress is basically,
Objection,
now
Your Honor.
you're
Motion to
saying
suppress not on file with the court.
Okay, so now you're saying you're going to file a motion to suppress? Is that what you meant when you said you wanted? I guess that goes hand in glove, Mr. Aguirre. It's a motion to suppress because he's arguing the officer didn't have cause to stop him. Now, but we can proceed if you want to go ahead and finish your arguments, Mr. Betts.
yeah, the reason I made that motion is because I thought we were going to trial on both of them. And I would have moved to suppress it at trial after the officer testified, unless there's a video of it.
Objection, Your Honor. Not currently before the court.
Well, there isn't a motion to suppress at this point, so Mr. Regier, you're certainly right. If you're ready, we can proceed on counts 1 and 2 if you want.
The state is prepared to proceed on count 1 per its earlier motions, and the state is objecting to any additional continuances in this matter.
All right, I'm not going to grant a continuance on this, Mr. Betts. You said even yesterday you knew that they were contemplating dismissing that as part of a plea offer. So you can hardly say it's a surprise today. Plus, you've told me that you were going to wait until you heard the officer's testimony. And so I'm not going to preclude you from doing that, waiting to see the testimony. But we have had this case scheduled for bench trial for quite some time. It looks like the ticket was issued April 9th of 2025. I'm not finding my docket notes. There they are. You've known since July 9th that you wanted a trial and that I granted that for you for today. So I am going to, your first appearance was July 9th. I'm denying the motion for continuance. I'm not going to proceed on a motion to suppress that hasn't even been filed. And Mr. Regier hasn't had time to even read what the allegation is, let alone respond to it. So, Mr. Regier, call your first witness unless there's any opening statements.
State waives opening statements and calls Trooper Philip Metzen to the stand.
All right. Mr. Betts, do you have any opening statements of what you think the evidence is going to show?
No, ma'am.
We've already discussed about. All right. Trooper Metzen, please raise your right hand. Do you solemnly swear the information you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may lower your hand, and Mr. Aguirre, you may proceed with examination.
Thank you, Your Honor. Would you please state your name for the record?
Philip Metzen.
Where are you employed?
I'm employed as a state trooper for the Kansas Highway Patrol.
Okay. And is state trooper your professional title in that capacity?
Yes,
Okay. How long have you worked as a law enforcement officer?
15 years.
And were you on active duty in your professional capacity on April 9th, 2025 at approximately 5:14 p.m.?
You
Yes,
said April 9th, Mr. Aguirre?
April 9th, 2025.
All right, let me double check my records. I've got it shown as 4/6. That could just be a typo. Law enforcement, way back in the show. I'll call up the actual charging document. I'm sorry, I called up Mr. Burns and I still have Mr. Burns on the screen. And this is Mr. Betts. Let me check this. Yeah, that'll make a bit of a difference. Yes, his does allege April 9th, 2025. So please proceed.
Thank you, Your Honor. At that date and time, Trooper, where were you at?
I was traveling southbound on the Kansas Turnpike, which is Interstate 35 at milepost 90.
And milepost 90 on I-35, is that in Butler County?
Yes,
Okay. Is I-35 a multi-lane highway?
it is.
Okay. How many lanes would you say?
There are 2 dedicated lanes for southbound traffic and 2 dedicated lanes for northbound traffic, which are divided by a concrete median barrier.
Okay. And when you say southbound, were you in an official vehicle of some kind?
I was in my patrol car.
Okay. And this patrol car, does it have any indications identifying it as a law enforcement vehicle?
It's equipped with emergency lights, a spotlight, and exterior grille lights. This particular car did not have any markings on it, as it's my normal travel car, and I have an unmarked vehicle for my current job.
Okay. Can you please describe your immediate surroundings as you recall them for the court?
While I was traveling southbound on the Turnpike or I-35, I came up upon a vehicle that was struggling to maintain a single lane of traffic. The vehicle was in the outside lane. I watched the vehicle for quite a distance, failed to maintain multiple times. And at one time, the vehicle had drifted to the left and allowed the driver's side tires to cross over the center dashed lane line. And the car was straddling the dashed lane line for a short distance, at which time I decided to activate my emergency equipment to conduct a traffic stop.
Okay. At this location, will you describe I-35 as a curving roadway or more straight?
This was a straight portion of the roadway.
Okay. Do you recall in this area if there are any trees or bridges, perhaps over the I-35 nearby?
There are trees along the side. I don't recall there being a bridge. There might have been overhead bridges, but there was nothing that we were traveling over.
Okay.
I recall.
And these trees that you referred to, approximately how far from I-35 would you say these are located?
From the actual roadway, they are located just beyond the KDOT fence. I couldn't tell you how far. If I had to guess, probably 100 to 150 feet off of the roadway.
Okay. Do you recall what the weather was like on the date and time in question?
It was a sunny afternoon or sunny evening. There might have been some clouds overcasting in the sky.
Okay.
As far as that, I don't recall it being a significant weather.
Okay. And do you recall if any of these aspects of the location that you referred to, did they impair your field of vision in any way?
No, the field of vision was open for miles.
Okay. Trooper, are you familiar with case 8262?
Yes.
Okay. What does that say about drivers with suspended driving privileges?
Well, that they're not allowed to operate a motor vehicle.
Okay. And does that apply for just a certain class of drivers with suspended driving privileges or all drivers?
All drivers.
Okay. Your Honor, at this time, I respectfully request the court take judicial notice of KSA 8262.
Taken.
Trooper, do you consider yourself capable of identifying traffic violations on site?
Yes.
Okay. Besides your 15 years of experience, I think you had previously referred to, do you have any recurring special training or continuing education requirements you're expected to meet?
As far as recurring traffic expectations, no, but I am assigned to a traffic safety motor unit.
Okay. And what do your duties as a part of this unit entail specifically?
I'm required to travel around the state, primarily teaching other officers and new police officers how to remove impaired drivers off the roadway, which includes looking for traffic violations. And then I am assigned to go out and do special enforcements, such as DUI saturation patrols, fatality reduction patrols, and then any like KDOT puts out step enforcements for high traffic weekends so that we can look for moving hazardous violations which cause fatality crashes on Kansas roadways.
Okay. So is it your testimony
court.
today that in addition to your
Was there an objection?
I said, if it pleases the court,
Sure.
I was going to say I would stipulate that I'm driving on a suspended license.
All right. Well, Mr. Regier can accept that stipulation or continue in the fashion that he wishes. So, Mr. Regier.
Well, that wasn't even stupid.
well, given your Honor, given the fact that the defendant has already stipulated, I'm not sure it's really necessary to continue on any further.
That's not. That's why I'm stipulating.
By stipulation, you're admitting that you were driving while suspended, Mr. Betts?
Yeah, a no contest plea to that.
All right, so now you're wanting me to stop the trial and entertain a change in pleas, is that right?
Yes, ma'am.
Well, I'm gonna let Mr. Regier proceed to present his evidence in whatever fashion he wants, but we'll come back to that plea that you're modifying. Mr.
Okay.
Regier.
Very well, Your Honor. When you observe these the vehicle being driven in the fashion you previously referred to, I think you said straddling the lane and periodic drifting. What happened after you observed the vehicle being driven in this fashion?
Well, I activated my emergency equipment to conduct a traffic stop, and then the vehicle pulled to the right shoulder of the interstate.
Okay. And where did this stop take place?
Southbound I-35, just south of milepost 90, so probably milepost 89.
Okay. And milepost 89, is that also in Butler County?
It is.
Okay. Once you conducted the stop, did you speak to the driver of the Nissan of this vehicle personally?
I did.
Okay. Do you recall the make of this particular vehicle?
Yes, it was a Nissan Altima.
Okay. Do you see the driver of this Nissan Altima present in the Zoom conference?
I do.
Okay. Can you point them out and give a brief description for the court?
It's the gentleman that has been talking. He's got like a whitish jacket on, kind of a darker shirt, got a mask underneath his chin that he's taking off now.
Okay. Your Honor, let the record reflect that the witness has identified the defendant.
The record shall so reflect.
Did you ever ask the defendant for identifying information during the stop?
I did.
Okay. What identifying information did you specifically ask for?
He provided me with his ID card.
Okay. Did you ask the defendant for a driver's license of any kind?
Yes, I did.
And did the defendant provide you with a driver's license?
He told me he was suspended.
Okay. So is it your testimony that during the stop, the defendant was only able to provide you with an ID card?
Yes, I believe so.
Okay. And do you recall what state this ID card was issued out of?
Out of the state of Kansas.
Okay. Did you ultimately write the defendant a citation for driving while suspended?
I did.
Okay. Your Honor, at this time, I respectfully request leave of the court to share my screen. As a precursor, the state does intend to introduce an exhibit in the form of the certified driving record. I am not sure if the court wishes to continue broadcasting on YouTube in light of the particular information contained in such a document.
We will go off the YouTube, but continue on the record, please, Destiny. And I do this because I don't want the alleged defendant's ID card to broadcast personal information about him that could be misused by someone watching unaffiliated with the hearing.
Okay, Your Honor.
785, State of Kansas versus Wendell Betts. We have been off of YouTube, but on the record, Mr. Regier did admit a document as State's Exhibit 1, which appeared to be the defendant's certified driving record, which would have been in effect at the time of the stop, April 9th, 2025. When we got ready to go back onto YouTube, Mr. Betts said he had some questions he wanted to ask. Sir, you will get a chance for cross-examination when Mr. Regier presents his evidence. You said you wanted to ask those questions before your certified driving record was admitted. Well, you did stipulate that you were suspended, and now you're wanting to challenge this certified driving record as being yours and accurate. Is that right, sir?
Yes, ma'am.
Well, you didn't make any objection when it was admitted previously or introduced previously. So I think your objection is untimely.
And Your Honor,
Yes,
the state would move the court to deny the objection on the grounds of timeliness.
And
I
it
didn't
is-
have an opportunity to make any objections, Judge.
You always
until-
have an opportunity to make an objection. I'm denying it at this time, but if during your cross-examination you want to review why it should not be admitted, I may consider that. Depends on
I appreciate
whether or not you have any legitimacy to that. But it is admitted, it was admitted, and the objection came after it was admitted that then you wanted to start questioning it after you stipulated to the suspension. Go ahead, Mr. Regier, if you want to finish your direct examination.
Yes, Your Honor, barring any redirect, no further questions.
All right, now, Mr. Betts, it's your turn to question all you want about that document or anything that the officer has testified to. So please proceed at this time. It's not your time yet to make statements or testify yourself, but you can ask questions. Go ahead, please.
Officer Metzen,
Yes.
did you have a video of me driving that car?
The Kansas Highway Patrol in my patrol car has a dash cam mounted inside the vehicle. And
Was
also,
it on?
Let him answer,
also-
please.
I'm
I was
sorry,
also wearing a body worn camera at the time.
with the dash cam video, was it on?
Operational at the time.
I'm sorry, Mr. Metzen, or Trooper Metzen, you cut out.
It was operational at the time.
Do you have a video of the stop or me driving within that lane?
I would have to get with the records and pull that video. It's electronically stored now.
And you indicated the reason for the stop was because I was swerving between the lanes? I never crossed over a lane, did I?
You're
Line.
Objection, Your Honor,
testifying
testifying on cross.
the stage. You'll get a chance
I'm
to
sorry.
tell what you
I
want
got
to
you.
tell. Questions only. Okay.
that the car crossed the lane.
That is the reason I stopped you, sir.
And that would be on the video. That
Correct.
correct? And when you turned on your lights, I pulled over to the right away, didn't I?
Correct.
And you testified that when you approached my car, you asked for license and registration. Is that correct?
Correct.
And I provided you with a registration. Is that correct?
Correct.
Insurance. Is that correct?
Correct.
I told you, did I tell you at the time that I didn't have a driver's license?
Correct.
I didn't tell you that my driver's license was suspended, did I?
Well, you told me you didn't have one. I don't recall if you were open about suspended. I typically ask people when they say they don't have a driver's license if they're suspended, to which I believe you agreed to.
Agreed to what, sir?
When I ask if somebody is suspended, you agreed that you were suspended.
Did I agree that I was suspended after you ran my license or checked my license or before that?
Before that, sir.
And you testified there was a sunny, nice day outside.
There was no inclement weather, which means there was no like excessive rain, snow, excessive winds that would, blow over houses or anything like that.
So your testimony is that just a nice day. Is that correct?
It was a typical day in Kansas.
And would I be wrong if I told you at that time it's windy out here?
I did not perceive it to be excessively windy, as I was not having a hard time maintaining the lane position of my patrol car.
Would you consider wind gusts of 42 miles per hour windy?
And excuse me if I'm a Matlock fan.
Objection, Your Honor. Foundation.
Sustained.
I'm sorry?
I sustain the objection. That means
Oh.
he does not have to answer that question. You'll either have to ask him another question or proceed in a different manner.
So is your testimony here today under oath that it was not windy that day?
My testimony under oath is that it wasn't excessively windy.
And can you explain to us what you mean by excessively windy?
That it wasn't windy to a point to where vehicles were getting blown off of the roadway.
And this vehicle wasn't blown off the roadway either, was it?
No, sir, your vehicle was having a hard time maintaining a single lane. And I stopped you before that could happen.
And when you stopped me, you asked me to do some field sobriety tests. Is that correct?
Correct.
You also asked me, required me to take, what's that test with the eyes, a nystagmus?
Horizontal gaze nystagmus, yes, sir.
And I passed that test, didn't I?
You did.
You asked me to take some a walking test, right?
Correct.
Walk and turn.
Okay, if he passed
Make
that,
it
he wasn't
count.
drunk.
I flunked that, right?
You didn't do so great on it.
I didn't, did I?
No, sir.
And I didn't do good on the balancing, did
Your
I?
Honor, the state would have an objection on the record on the grounds of relevance.
And that is sustained because he's not charged with DUI. So unless you have some, can
Also, you didn't do well. I'm just saying.
demonstrate some purpose or relevance
You need an adverb there.
to these questions, I'm going to stop them at this point. Because he did not charge you with DUI.
One of yeah, Judge, I think it is irrelevant because one of the reasons
Objection, Your Honor, arguing on cross.
Well, he's making an argument to the court. He's not arguing with the witness.
I think he did say, Judge, I think it's irrelevant. Judge corrects it for him, but it's still funny.
He's trying to prove to me why it's relevant that he was given the DUI test. Go ahead. I'm going to let you do that.
one of the reasons I'm asking that question, Your Honor, is because it was difficult to maintain balance because it was so windy out there.
All right, now you're doing two things. You're starting to testify, which you can do, but just not right now during his testimony.
Okay, all right, I got you.
And you've asked and answered questions that he's given you his answers to. So
Okay.
if you, I'm going to sustain the objection.
I'll go on.
All right, good idea. Go on.
And you asked me to provide you with ID, is that right?
Correct.
Did you say idea, sir, Mr. Betts?
Identification,
ID, okay.
is that correct?
Correct.
And I provided you some identification, did I not?
You did.
And you testified earlier that my identification listed my address as the same address on the document that the prosecutor showed you, is that right? 1522. Is that correct?
I don't recall if I took that, if that's what's on your driver's license, but I typically ask you if the address on your driver's license is still current. If it's not, then I ask you what your current address is. That is how I got your address.
And it was 1522 North Pastor, right?
Correct.
And did I tell you I had just moved to North Pastor within the last month?
I don't recall that, sir.
So the identification that I provided to you only had my name on it?
Objection, Your Honor, testifying.
Oh, I'm
That's a
sorry.
question. It's a question. He can answer if that's all it had on it or not. If he recalls, it's been a while.
I understand.
Re-ask your question, sir.
Can you see this?
Do you want everybody to see that on YouTube?
And Your Honor, the state would object to this being admitted as an exhibit due to lack of foundation.
It's not even marked as an exhibit. So if you want that to be an exhibit, you need to proceed with in an appropriate legal fashion, sir, to get it, as counsel said, to lay the foundation.
Well, I have to have it marked first, don't I?
Is it marked? I don't recall marking it. Did someone else?
No, I'm asking you. I want to mark this and then ask them questions about it.
And what is this? What do you allege it is, Mark? This would be defendants A, and what are you telling me this is?
It's an identification card that I provided to Trooper Metzen.
Well, that's what you're proposing that is your ID card that would have been in effect April 9th of 2025? All
Yes.
right. Okay, well.
And Your Honor,
Go ahead.
Your Honor, again, there is clearly a lack of foundation on the record, so the state would have it be denied as an exhibit.
Well, he's either going to have to
Before-
lay the foundation through the officer's testimony or through someone else's.
Judge, I was just initially just marking this and then
Your Honor,
I,
Your Honor, the state would
Hold
also.
on, Mr. Regier, let him talk too, and then we'll come back to you. Okay, so the offer, what's before the court is a request to mark, as defendants say, a purported ID card for the defendant, correct, sir? Mr.
Correct,
Betts?
Your
And I have no problem with that being marked as Exhibit A. Now, if he wants to start admitting it, that's a different story. He will have to to lay some foundation and go from there.
That's what I was attempting to do, Your Honor.
All right, and you think you can lay that foundation through this witness?
Absolutely.
All right, and do you want to be on YouTube doing that, or do you want to go off YouTube but stay on the record to show that to him? Because if it's got
Yeah,
the
I have my
information I'm
doubts.
familiar with on those kind of cards, it's pretty personal.
I have no problems. I don't want to be on YouTube, period, but I have no problem having him.
Well, this is the first time I recall hearing you object to YouTube.
Oh, come on.
I
YouTube's
didn't know we
fun.
were on YouTube, Your Honor. It's my first time doing something on the Zoom.
All
Yeah.
right. Well, if you want anybody watching YouTube to see your record or to see you hold up your card so that this officer and I can see it, and Mr. Regier, I will let you do that. If you want to do it like we did your certified driving record to protect your confidential information, I
Yes,
will
ma'am.
let you do it that way.
Yes, ma'am.
You want to take it off, keep it on the record, but take it off of YouTube. All
That's
right.
correct.
Destiny, can we do that? I don't think he's going to probably. Do you know how to screen share documents, sir? Do you know
Me?
what?
We're back on YouTube, Your Honor.
We'll take that
All
as
right,
no.
we're back on YouTube, providing a full public hearing to Mr. Betts, the defendant, and we are addressing redirect on Mr. Regier's part. If the state wants to proceed where I interrupted you.
Thank you, Your Honor. Trooper Metzen, you previously testified that during the stop, the defendant provided you with a Kansas state ID card. Is that correct?
That's correct.
Okay. Is there anything about today's hearing which causes you to amend your earlier testimony?
No.
Nothing further from the state, Your Honor.
All right, and he recrossed. You can only question about him what he just answered questions to. You can't go into another direction or start something new.
I understand, Judge.
Okay, thank you.
You testified that the driver, me, provided you with a
Thank you.
Kansas identification.
That's what I recall.
And on that identification would have listed my address.
Correct.
But you felt it was necessary to ask me what my new address was.
Your Honor, outside the scope of recross.
I think I'm going to let him answer that. Go ahead, Mr. Metzen. If
I love it. I think it is actually. It's close. You could go either way. The judge's ruling doesn't bother me, but the objection's good. I just like Regier taking it to a pro se. I love it.
if that's what happened.
I'm just asking questions about.
Okay, you asked him if you gave him an ID, Kansas ID, and he said yes. And then I think when the objection came in, you were asking him, yet you asked me my address. Is that the way you all remember it? If you want to pick up from there.
Well, yeah, I asked him if the address is on the Kansas, will it appear on the Kansas identification card? Like a driver's license.
Yes, it will.
And you're basing your testimony that 1522 was off the Kansas identification card I showed you?
That, and I also asked you if this was the correct address, to which you agreed to.
You said I agreed that was the correct address on the Kansas identification card?
That's what I recall you telling me.
Oh, he's really got the officer on the ropes here. The officer asked to verify that the address is in fact his current address and it's updated. Wow.
I don't have any further questions.
All right. Trooper Metzen, I'm going to excuse you, although Mr. Regier Do you want him to stay around in case you need him for rebuttal or any other purpose?
That would be the state's preference, Your Honor.
All right, so Trooper Metzen, if you have time and can continue to wait for the conclusion. Do you have any place else you have to be?
I'm just in the middle of teaching a DRE class here in Salina, Your Honor, and I need to get back to teaching them.
And that is a pretty important class. Well, will you be available if Mr.
Oh, so you don't want to march up and down the square.
Regier needs to call you? Do you have a
As long
telephone, a
as-
pager?
I can remain on the Zoom as long as I can mute the audio.
That'd be fine.
I will still be paying attention as far as what's going on.
All right, so you'll be continuing to teach your class, but you'll hear us. If we call for you, you can come back.
Yes, Your Honor.
Something similar to that anyway. Okay, I'm gonna let you do that because those classes are important and they're only so often, and so go ahead.
Thanks, Your Honor.
You're welcome. You can mute and go off camera for the time being. That way we'll kind of keep him available, but not keep him from doing his other obligations too. And I believe, Mr. Regier, you were through with him, correct?
That for short of calling Trooper Metzen as a rebuttal witness, Your Honor.
All right, do you have any other witnesses, Mr. Regier?
No further witnesses from the state, Your Honor.
All right, does the state rest?
The state does so rest, Your Honor.
And that is with your exhibit admitted. The driver's license, the driver's record, I'm sorry.
Thank you, Your Honor.
Okay, Mr. Betts, do you have any witnesses you wish to call to testify? You can do so yourself if you want, or you can call others or both.
No, I'm just gonna testify myself, ma'am.
All right, then please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, thank you. And if you just identify yourself, you are the defendant, Wendell Betts, in this case.
My name is Wendell Betts. My current address is 1522 North Vassar. I moved there in April of 2025. I've lived at 3737 Southwest Plaza Drive in Topeka, Kansas for 8 years. Prior to that, I lived at 3737 Southeast Howard Drive for 30 years. I was stopped by Trooper Metzen. He asked me for.
And if I may, sir, just a moment. And do you agree that you were stopped April 9th of 2025 at about 5:14 p.m. on the Kansas Turnpike in Butler County? Do you take any issue with that?
No, I don't.
All right, because if you do, now would be the time to testify to your version, but go ahead, please.
Trooper Metzen asked me to produce license, registration, and insurance. I told him I did not have a license, not that it was suspended. I didn't know that. I gave him my military ID as identification with the picture of me when it looks like I was younger. That was just a few years ago, young. I got more gray hair now.
I understand.
I asked him why he stopped me, and he told me that I had been weaving back and forth. I told him that it was pretty windy out there, and if I don't have I told him it was pretty windy out there, and that was the reason I may have been weaving within that lane, never crossed the lane. I did some driver's tests. And I was unable to do them because my balance was off. I couldn't walk the line, walk and turn. And so,
No hurry, Grandpa. We got all day. You just you just let this slowly fall out in whatever pace you feel comfortable.
and that's it. I have no further statement.
Now, at some point, did you announce to the court that you stipulate that your license was suspended at the time? Or not? I recall you saying that. I don't recall what part of the proceeding you said that.
Well, that was before I saw the certification. And I got a ticket for driving while suspended, so I assumed it was for suspension. But
Now are you withdrawing your stipulation that you're suspended? You're saying you weren't?
no, I'm still. The document said I was.
Okay. All right. Anything else?
Well, about the document, Your Honor, at notice, I didn't live at 1522 North Bassett. My driver's license have never said, well, since I was 21, has never said anything about me living at 1522 North Bassett. My driver's license was 3737 Southeast Howard Drive. That's where I was living. My registration says that. I didn't bring it and mark it as an exhibit, but it's in the car. And my insurance says that.
Objection, Your Honor, hearsay.
Yeah,
Do you have the documents with you, sir?
My registration? Yeah, it's in the car. I keep it there.
Do you have your insurance with you? You don't have, is it available?
I don't know if I got that or not.
Okay, so what's your testimony today about the documents? Can you repeat and restate?
That certification, suspending my suspending that driver's license. I never received that. It was sent to 1522 North Bassett. I didn't live there. Haven't lived there in years.
Okay.
Every time I go down and re-register, I put down 3737 Southwest Plaza Drive until in Topeka, Kansas.
Anything else at all, sir?
No, ma'am.
All right, then I need to turn it over to Mr. Regier for cross-examination. He can, if he wants, ask you questions about what you've testified to, since you're a witness for the defense. Mr. Regier?
No questions, Your Honor.
All right. So do you have another, that means you can call your next witness if you have one, Mr. Betts?
No, I don't have any other witnesses.
And does the defense rests then that you're not calling any more witnesses or presenting any more evidence?
I rest.
All right. Any rebuttal, Mr. Regier?
None from the state, although the state is prepared to make closing arguments at the appropriate time.
All right. If the parties have both presented all the evidence they want, and I understand you have, then I am ready to hear any closing arguments you have. And after that, I will make a ruling as to whether the evidence is sufficient to convict or not. Okay, so Mr. Regier, as plaintiff, you can go first. I'll give you a little bit of rebuttal if necessary.
Thank you, Your Honor. Your Honor, pursuant to KSA 8262 subsection A1, quote, any person who drives a motor vehicle on any highway of the state at a time when such person's privilege to do so is suspended, or while such person's privilege to obtain a driver's license is suspended, shall be guilty of a Class B non-person misdemeanor on the first conviction. Here the evidence is clear. The officer has identified the defendant as the driver. The defendant was driving the Nissan. The September 18th, 2018 notice of suspension in the certified driving records includes suspension date also of September 18, 2018 before the April 9th, 2025 stop, includes both the defendant's name and address, and specifically cautions, quote, your driving privileges have been suspended on the date shown above and will remain suspended until one of the following two requirements have been met, and a stop occurred on I-35, a multi-lane highway, in Butler County, Kansas. Notwithstanding any allegations the defendant might be making about the issue of notice, the case law in this case is quite clear pursuant to State v. Jones as handed down by the Kansas Supreme Court, finding that, quote, the state must send a copy of the order of revocation or suspension or a written notice thereto to the licensee at the last known address according to the division's records. And when the written notice has been mailed, then after a reasonable time for mail delivery has expired, receipt is conclusively presumed, and that in a prosecution under KSA 8262, the state need not prove actual receipt of the notice, actual knowledge of the revocation, or specific intent to violate the statute by the licensee. State has nothing further, Your Honor.
All right, now then, Mr. Betts, it's your time to make any closing arguments you want to
Take that, Mr. Betts. That's just a whole bunch of law right there.
make. And they
I'll
should
keep-
be based on the evidence you've been presented. It's not time to bring up new evidence.
I'll keep it brief, Judge.
Okay, go ahead.
I never received that notice. I don't know how they got 1522 North Fats unless it was done after I was stopped, prepared that time. The violation occurred in 2013. The notice was sent in 2018, I believe. I didn't know my license was suspended. I knew it had expired, but I didn't know it was suspended. And Judge, if you think if I'd have got that notice, I would have just ignored it, not paid that little amount of money that I think that's what it's required to pay something. I would have paid it. Got to reinstate it. That's it for me, Judge.
All right, thank you.
I'm
Thank you.
sorry.
Bo.
I'm sorry this took so long. I didn't think it was going to take this.
That's all right, Mr. Betts. You are, as a citizen, entitled to a trial, and don't worry about exercising your right to that trial at all. Both parties have presented their evidence and have rested. They've both made their arguments. Mr. Regier has accurately recited Kansas law. Mr. Betts, you'd be amazed at how many people move without changing their address on their driver's license. And as Mr. Regier said, Kansas law says Topeka just has to mail the suspension notice to the last address that the driver gave them. And if you don't let them know that you've moved, then they can send it to the last known address, and that counts. And that's what the certified record looked to me like they had done. They'd sent it to that Vassar address. And, but they showed that they had legally sent that. Now you said, would I have expected you not to pay a little reinstatement fee? I'm not sure where that was going, because I saw that the record showed that you had been suspended for something to do with a DUI conviction previously and a cancellation to do with insurance, as I recall from the certified driving records. But in any event, those records did show, for whatever reason, you were suspended on April 9th, 2025, at the time the officer would have stopped you. And the state showed that the notice of suspension was sent prior thereto to the Vassar address, which complies with Kansas law. There was quite a bit of talk about what you showed the officer, Mr. Betts, whether it was a Kansas driver's license. I don't think anybody says that. Was it a official Kansas driver's license that looks a lot like an ID card? Or was it a Kansas ID card, I should say, that looks like a Kansas driver's license? Or was it the VA card that you showed to the court? The officer says that whatever you showed him, he said it could have even been the registration on your car or the insurance to your car, but in any event, it had the Vassar address, and that whatever document he looked at, he wasn't certain which one he got that at Vassar address, but he said he did ask you about it, and you did confirm that that is your current address, what you had at the time that he stopped you. And the only reason that address in this case I think is significant is because it goes to the defendant's argument. Well, I'm not sure what that goes to, because the bottom line is, was the defendant suspended when he was driving? And from what I can tell beyond a reasonable doubt from the certified driving record that I believe truly does identify this defendant and was mailed and did show suspension on April 9th, I conclude it does show that the defendant was suspended at the time he would have been driving. And in fact, at some point, the defendant told me during the testimony that he stipulated he was suspended at the time. And then he said after he looked at the certified driving record, he decided maybe he wasn't. But when I looked at the record, I was more convinced that he was. So I find the defendant guilty of that charge. And he is not charged with DUI. The officer, I can see where may have pulled him over and checked him just to make sure, since the officer testified that he was going back and forth in the lane and on the center line, drifted to the left, tires crossed over, and he stayed on the center dash lane for a while, and then at some point he went off the edge too. So I find you guilty of both counts 1 and 2, sir. And like I said, the DUI is not, in this court's opinion, relevant, because no one even suggested you were DUI at any time other than you yourself brought it up. Let's see, that driving while suspended is a B misdemeanor. The fines can be at least 100 up to 1,000 and 6 months possible jail with probation and option. The driving on a laned roadway, improper driving on it, is an infraction. Mr. Regier, you have recommendations for sentencing?
Your Honor, if the court is prepared at this juncture, notwithstanding the state's pretrial motion to dismiss count 2 to find the defendant guilty of counts 1 and 2, the state does have recommendations.
If you want, okay, if you're maintaining, okay, so if you're maintaining that count 2 is dismissed, I will let you dismiss that. I will not find the defendant guilty on that. I will just find him guilty on count 1. So are you still maintaining your dismissal of count 2 or not, Mr. Regier?
Regier's heart grew 3 times this day.
Your Honor, the state had made that motion prior to pre-trial, and the state would have certain procedural concerns if the state were to shift the proverbial course following trial.
All right, so at this point, we'll only be sentencing on count 1, the state having dismissed count 2. Your recommendations for sentencing on driving.
Why didn't we just take the damn plea? Right there, he said, I'm going to plead no contest to this. There was discussion mid-trial. And then she says to her, Gary, you can present whatever evidence you want. Right there, you say, well, if they're going to do that, then I will honor my pretrial offer, even though he didn't take it. I will honor my pretrial offer to dismiss the other count. I don't get it. I think you just wanted to smack him around a little bit. And then still give him the break at the end. I don't know. It's fun.
Canceled, suspended, or revoked, Mr.
Yes, Your Honor. In this matter, the state, besides recommending court costs, the state is recommending a $400 fine. The maximum underlying sentence allowed for a Class B misdemeanor of 6 months, subject to a year of non-reporting probation. The state.
This is like sport fishing. You just catch him and throw him back. He's like, I got you convicted on everything, but it's okay. You're a charming old guy. You didn't hurt anybody. I'll go ahead and dismiss it now.
As previously indicated on the record, this is a case where it would appear that the statutory requirements concerning booking are still outstanding in contravention of prior court orders, as it were. So the state will defer to the court as to how it wishes to proceed on that front.
All right, Mr. Betts, you don't have to make recommendations before sentencing, but you're welcome to if you want.
Can you bring me the processing sheet?
I don't have any recommendations other than to submit to the court that as soon as I leave here, I intend on going over to book myself in and get my
Yeah.
picture taken. And,
All right.
Judge, that will not happen today either.
oh,
They get done at 3:30.
Okay. All right, well, at this time, Mr. Betts, I do impose a fine. I'm going to make that a $200 fine and $108 in court costs for a total due of $308. Are you able to pay that today or do you need some time?
I can pay that today, Your Honor.
All right, I'm going to order that you pay that today as you leave the courthouse, go by the clerk of the district court. Your jail sentence is 6 months, but I'm not going to make you serve that as long as you can successfully complete a non-reporting probation that will be for 1 year. You do not have to see a probation officer, but you will nevertheless be on probation. Your probation condition, number 1, is violate no laws during this 1 year probation. Number 2, pay the $308 today before you leave the courthouse. And then number 3 is do that processing whenever the officer tells you to get it done. You need to get it done this time. That's a condition of your probation. Kansas law requires me as a judge to order that you do that. I ordered it, you didn't do it. You better
Right.
do it this time. Excuse me?
You-
Someone
you
talk.
want- I was talking to somebody else. You won't have,
Oh,
I won't have a problem doing that, Judge. Whenever they tell me to be here, I'll be here.
okay, very good. Well, if you do those 3 things, then you shouldn't get your probation revoked and you shouldn't have to serve any jail time. If you do violate those conditions, it might be a different situation. You may get revoked and you may have to serve. So again, $400 fine, 108 court costs, total of $508. Due today, 6 months suspended jail sentence in lieu of 1 year non-reporting probation with conditions violate no laws, paid today, and process your prints and picture as instructed by the
Judges.
officer.
It's 308.
308.
Yeah,
I
you
thought you
both-
recommended. I thought you recommended
The state's
400.
recommendation was a $400 fine, Your Honor.
Oh, and I gave him a $200 fine. That's okay. I've got 2 sets of notes here. Yes, it's 308 because I did reduce the fine in half to 200. Thank you
And
all.
I appreciate that.
Okay. Now then, you do have the right to appeal this up to 14 days after the journal entry is filed. You can appeal this. If you do appeal it, before the appeal is filed, I am ordering the clerk to accept a $308 cash appeal bond so that if you don't prevail on your appeal, which can take some time to the Kansas Court of Appeals, that money will be there at the conclusion of the appeal. If you win your appeal, it can always be given back to you. You have to appeal to the Kansas Court of Appeals. You don't just get a new trial. You have to have legal reasons that you can put in written form what you think, what laws I violated in making the wrong decision today, if that's what you think I did. And you may need an attorney to help you do that unless you're able to do it on your own. And if you can, that's great too. But that's my orders at this time, Mr. Regier, to journalize and to get a copy to Mr. Betts of what the court has ruled today. Now, Mr. Betts, let's get your address straight. Are you on one of those 2 Topeka addresses or are you on that Vassar, Wichita address?
1522 North Vassar, 67208.
All right, make sure he gets a copy, Mr. Regier, please. That will be the order. And if you don't get one within a month, be calling the court and find out the court or Mr. Regier and find out where your copy is because you're entitled to that. And if you don't, I'm going to say call within 14 days if you don't have it because that can affect your appeal time.
Your Honor, can I interrupt you for just a quick second?
Sure.
What was his OR bond for that booking and processing? Are we referring to what it was last
Well,
time?
with the booking and processing, I'm not going to make him post a bond now because his case is concluded. I'm not going to make him come back. So he doesn't have to have an appeal bond. You want to?
That's okay. I just wanted to make sure for noting reasonings, but that sounds good. Thank you.
Okay, all right. Thank you. I appreciate that. All right. Anything further, Mr. Regier?
Not from the state, Your Honor, besides thanking Trooper Metzen for honoring his subpoena this afternoon.
Yes, especially in light of his double booking there. And Mr. Betts, anything further from the defense?
Nothing other than thanking Trooper Metzen for giving me an opportunity to leave that day. He didn't have to, I don't think. I appreciate that.
You're welcome.
Oh,
All right, well, thank you both very much, and we will be in recess. Both Trooper Metzen and Mr. Betts are excused from today's proceedings. You may both leave.
oh, that was kind of sweet. If I would have known that, I wouldn't have done it. This all started from Alyssa. She thought I was this offset, which I get because he was rambling about traveling for a little bit. And then I started looking at it. But what happened was there are 3 parts to this thing. So big shout out to Zach at Leonard's Unite and Brecken, both of which were scrambling to help me because I was trying to put this thing together and they kept going off. So I had to try to get the video because they pulled the video. So I had to try to get the video while trying to stream, and it was a whole situation, but it worked out well. It worked out well because I'm a YouTube professional. And sometimes I go a whole day without muting myself. Not very often, but once in a while I do. So thanks again to Alyssa, Zach, and Brecken, all coming through for me. Thank you all for coming out. I appreciate it. I will see you all soon.